Stitch People. Welcome to the Stitch People podcast. I'm Lizzie Bean, your host, and the founder of Stitch People, where our goal with cross-stitching is to inspire your personal creativity, and our goal with podcasting is to help you make some new friends while you're at it. Today's episode is a little bit different than the other episodes of our podcast. We are interviewing, instead of a member of the Stitch People community, our intellectual property lawyer for Stitch People. There is a lot of ambiguity and a lot of questions in the arts and crafts and arts and creative fields in general, especially around ideas and work and intellectual property at large. So we thought it would be really helpful and really valuable, considering a lot of you are makers in your own right. You might have Etsy shops, you might sell at craft fairs. What protections do you have and what actions can you take? Those were sort of the questions that I had in mind when I started thinking about what I could do to talk about this on the podcast. So I reached out to Lindy to see if she'd chat with me. She said yes, because that's just how amazing she is. And I do want to disclaim on my behalf, on her behalf, this episode does not constitute legal advice, of course. It is a very general discussion about what intellectual property is and intellectual property and copyright law in general. My hope is that you can learn something, that you can maybe learn about something that you didn't know before and at least have some new seeds of things to think about. Maybe this will teach you about what kinds of terms you want to Google and research more and what kinds of action you might want to take for your small business and your works of art. So without further ado, let's hear my conversation with Lindy Herman, intellectual property lawyer. Welcome to the Stitch People podcast. Lindy, thank you so much for taking the time to join us today. Everyone, just by way of introduction, Lindy is our intellectual property lawyer for Stitch People. She's helped us register our copyrights and our trademarks and all that kind of stuff. So Lindy, can you tell us a little bit more about you and introduce yourself to us and tell us a little about what you do?
Sure. I have been an intellectual property attorney for 16 years now. This is not what I planned on doing with my career. My background is actually in museum work.
Aha, I think I forgot that.
Yeah, and so while working at a museum, I met the museum's intellectual property attorney. I had not even heard of intellectual property, and he started talking to me about artist rights and in particular copyright. And it just fascinated me. The whole concept of you can protect an artist's work from being copied was just wonderful to me, because I remember myself as a kid when we would have art in elementary school, I would stand all my books up on end around my desk so people couldn't see what I was doing. And so I had never heard of copyright. So the day after that meeting, it was a manager's meeting related to all of copyright issues that museums face. The day after that meeting, I called him and I said, "How do I get your job?" And so then I went to law school and became an intellectual property attorney.
Oh my gosh, that is so cool. What a lightning bolt of clarity and passion. That is so neat. Okay, yeah. I have to ask before we get into the nitty gritty, are you still an artist? Do you still have artistic inclinations?
I do. Yeah, as a side hobby type of thing.
That.
Yeah.
What do you do? What's your
right now mostly
outlet?
Just like drawing and such, but really anything that I can create, like stained glass and things and sewing, things like that. So yeah, but then I just end up with a bunch of stuff around my house, and so it's kind of a struggle.
Know the feel. I'm sure everybody listening is probably like, yep, we have all the things all over the place. Yep. I love it. Well, let's dig in. I have been looking forward to this interview because Stitch People is a small business, crafting business that, we have our own designs and things like that. And we have a large following of people who are also artistically inclined, and a lot of people who are making their own patterns and art of a lot of different mediums in their own right. So I thought this would be really valuable for all of us to kind of learn as much as we can in, just a little short amount of time about just a little bit about, like you said, you had never heard of it before and how exciting it is to be able to protect your intellectual property. So can you first tell us what is intellectual property? Kind of what is it? Where did it come from? What does it entail?
Sure. Yeah. There's a somewhat large group of different concepts that are considered intellectual property because they're not tangible, and they're created out of knowledge. And so I'll run through the basic categories and just basically what they cover. So if anybody of your listeners are out there saying, hey, that might apply to me, at least they have some direction to go in. So we'll start with a couple of things that I personally don't do, which are patents and design patents. So patents cover inventions. So if you if you can solve a problem or you can make something easier, that's when light bulbs should start going off thinking, maybe I have an invention here. So something new, useful, and not obvious. So patent prosecution, the term prosecution means getting registrations, whether it be getting a registration for a trademark or getting a registration for a patent. Patent prosecution is very, very specialized. In order to be an attorney that prosecutes patents for clients, you have to have a science degree.
Whoa.
I never want a science degree. My degree in history and museum studies and French, not science. So it's a very technical area of the law. There is a type of patent called the design patent that protects the way something looks. And that could be the shape of something, or the color of something, or the shape of a part of something. Those are, they're not as technical, but it's still something you have to use a patent attorney for. And something to remember with patents is that there is a deadline to file. So if you come up with an idea, don't sit on it for a couple years. Don't tell everybody about it. Talk to a patent attorney right away, because you have a year in the United States. That is the main one. The remainder of the stuff for me is the fun stuff. That to me is like science. Okay, we'll let the scientists do their thing. Okay, so trade secrets is another category. That is like the Coca-Cola formula or the KFC spices, something that is usually not protected by some other type of intellectual property. And it's valuable to you by nature of it being a secret.
Like the Coca-Cola recipe, because they're the only ones who have it. It's special to them and their company.
Cool. And it's other things that could apply to pretty much any business that would be a trade secret are customer lists, pricing, especially your vendor pricing. If you buy in bulk and you get a discount, those are the kinds of things that it's valuable to you because you've negotiated that and other people aren't privy to that. So trade secrets, right of publicity, which some states also refer to as right of personality. This is an individual state law. And it is the right that everybody has, you and I, even though we're not famous, you a little bit more.
To cross-stitchers.
So everybody, regardless as to whether or not they're a celebrity or completely anonymous, they have the right to control their name and likeness in their name, image, and likeness in using that in a commercial context. And so there was a case, it was out of the UK, but it's under the same law, where H&M hired a photographer or bought a photo from a photographer, put it on the front of a shirt, and that photo was of Rihanna. And Rihanna's like, I don't support H&M. I didn't license this. So even though they had the copyright to the photo that they bought, they were using her image in a commercial context without her permission.
Is that where something would fall into place? Like I've heard, a lot of historical figures or public domain stuff, that technically the likeness of someone who's been dead a very long time, as long as there's not like a trust or something around them and their family, sure, they are technically like referencing them or quoting them as in the public domain. But you have to, you can't use a specific photograph of that person because technically the photographer owns that photo. And so you have to be sure that no one owns rights to the photo of the person, even though the person might not be alive. Interesting.
Yeah, and that is a really good example of where one work can implicate multiple rights. So you have to look at it through these different layers. And if the person's been dead for a long time, like you said, there's not a right of publicity issue for, George Washington. Now, right of publicity is governed by individual state laws, and in some states, the right of publicity continues like any other piece of property after the person dies. And a good example of this is Tupac. He was at, he did his hologram performance. I think he might still be, So his mom actually owns his right of publicity. So she has the right to control the use of his image and name and all of that for commercial purposes for a certain period of time. And that is determined by where depending on the state, where that person died or resided when they died.
Interesting.
So she still gets to benefit from that asset from him because it had value to his estate.
I also, this is just like a lot of people know that I do acting and performing. I love, TV and film. I have heard that a common mistake for new actors, if you book your first recurring role, you're on the next Seinfeld or Office or whatever the next big hit series is, that a lot of actors forget to address likeness rights in their contracts.
Yeah.
And so then NBC or ABC or, whatever network you're working for technically can put your face on anything if you're not careful with your entertainment lawyer to make sure you've tightened up those likeness rights.
Exactly.
Fascinating.
And those type of licensing, you might have something along the lines of, you can use my image to promote the movie,
and movie posters
only
and trailers and things.
Yeah, exactly. Movie posters and trailers and things. But does that extend to all of the other merchandise like T-shirts and mugs and So that's where your right has value. Again, it's an intangible thing, and there's value to it.
Right, but the reason someone wants a T-shirt with Rihanna's face on it is because Rihanna is marketable and sellable.
Exactly.
People like her. And that's why they want the T-shirt. So it's her fame, even though that is an intangible thing, that makes them want her on the shirt.
Exactly.
So I can see that's so interesting. Okay, I'm not going to go to law school. I'm deciding right now I'm not going to law school. I'm not going to law school because it's very interesting. Okay, so we've got next trade secrets. We've got likeness rights. Yeah, keep going. Tell us more.
Trade dress. Trade dress protects the way that something looks, similar to a design patent.
Okay.
But it's for a different purpose. A design patent, something that's covered by a design patent, doesn't need to be sold. There doesn't need to be any recognition. It just covers that, and that's it. Nobody can copy it. That's the end of the story. Trade dress is a way of branding. It's like a trademark, but it covers, for example, I'm just going to give you the best examples. It's the shape of the Coca-Cola bottle.
Oh, perfect.
So if I held up a Coca-Cola bottle with no label on it, you're going to know it is a Coke.
Yep.
And that is trade dress. But the difference between a design patent and trade dress is that consumers see that as a source indicator. They know that that bottle comes from Coke. It's used in the sale of products, and it's intended for consumers to easily recognize a brand.
Yep. And Coke wants to protect that because I could start my own soda brand and say, well, people really like that swoopy glass bottle.
Exactly.
And that would arguably help my sales, but it would only help my sales because Coca-Cola did it first and made it popular.
Exactly.
So they get
people would
to benefit from that.
Buying a Coke.
Exactly.
Yeah. So,
and brand confusion.
Exactly. That's exactly a confusion. You would be capitalizing on a recognizable aspect of Coke that makes people recognize their brand.
Interesting.
Similarly, the orange Tide bottle. They're the only bright orange Tide bottle. Bright orange laundry.
I don't know that I've ever thought about that, but you're totally right.
Yeah.
Orange is Tide.
Yeah. And so the next category is trademarks, which does the same thing as trade dress. It's intended to be a source indicator. And it's I use Nike as an example. You have Nike, the word Nike, have the swoosh logo. You have Just Do It as the brand, as the tagline. And so those are all examples of really good trademarks. They're unique. They're not descriptive. They are, well marketed so that Nike's built up that brand. And when you see that swoosh on something, you don't even have to have any wording or anything around. You'll see that swoosh and you'll know it's Nike.
Totally.
So that's a trademark. And then the last one, which is going to be probably most applicable to your audience, is copyright. Copyright protects original works of authorship fixed in a tangible medium. So it doesn't protect ideas or concepts. It protects a specific work. Like I'm looking at this background behind you with monkeys and leaves and jungles and flowers, and that is protected under copyright. It's a work of art.
Yeah.
Other examples would be music, movies, which we've talked about, literary works. Actually, software is considered a literary work.
Oh, interesting.
Yeah. And although software has evolved today to where you can do the same thing with different code, but you can still have the same kind of outcome. And so it's still valuable, but it's definitely an evolving area of copyright law.
That reminds me a little bit of how, because I actually majored in music, and I majored in like commercial music studies. So I remember we talked a lot about music copyright, and you can't copyright chord changes, for example. So I would imagine that there's what you just said about software reminds me of, because there's only so many ways to code a thing, but it can have a different outcome, and that's where it gets important. Same thing with a chord change. You've only got so many keys on the piano. You've only got so many alphabet letters. You've only got so many, so you can't copyright the alphabet, but when you write it into a novel, that's what becomes copyrightable.
Exactly. That is the best way to describe it.
Right.
Yeah.
Interesting. Okay.
That's a really good analogy. I'm going to use that in the future.
Oh, there you go. Yeah, because that's music. People get all precious about their songs. You can copyright melodies, I believe, but you can't do chord changes. So I've Got Rhythm and the Flintstones song use the exact same chord changes, but their melodies are so different.
Oh, I didn't know that.
Yeah.
Okay.
So there you go.
That's great.
So can you tell me that you mentioned the word descriptive about trademark. You said it has to be unique, can't be descriptive. What does that mean?
Okay. So in order for something to be protected as a trademark, it has to be distinct. Distinct is the word that we use. And in order for it to be distinct, it means you can distinguish, it allows consumers to distinguish among the various marks. Trademark, first and foremost, is a consumer protection focused law. It is intended to protect consumers from being confused as to the source of a good or a service.
Gotcha.
And it's great that it also gives protection to the brand owner and allows them to, protect their brand and enforce their brand. But the primary focus is to keep consumers from being confused.
Sure.
So in order for that to happen, the mark you have to be able to distinguish one mark from another. So we have something called a distinctiveness spectrum. And on one end of the spectrum are really good, strong marks. On the other end are words that aren't even protected as trademarks. So the really strong marks are completely made up words like Xerox. That's a really strong mark. It's totally made up. And, there's no way somebody's going to confuse that with, an already existing word.
Right.
Next category are arbitrary marks. Arbitrary marks are existing words, but they have nothing to do with what's being sold under them. The most famous, the most well-known brand right now is an arbitrary mark. It's Apple. If I said, hey, do you have an apple? You're probably going to think of your phone before you think of the fruit.
Interesting.
So that is an arbitrary mark. The next category are suggestive marks, which are somewhat descriptive, but they barely cross that line into being not descriptive, like Staples for an office supply store.
Okay. That's a really good example. Because as you're talking, I'm trying to think of ones. And Staples, because it's like related, but it's not just Staples.
Exactly.
And staplers.
Yeah. And so the next category is the descriptive marks. And descriptive marks is actually cut into two categories. So a descriptive mark that is just straight descriptive is not going to be protected because other people will use those words to describe their own products or services. And thus, it can't be distinctive. It can't distinguish if you're going to keep seeing it over and over.
Sure. Like if you started a business called the Hot Tub Company.
Exactly.
Or
That's
something.
Perfect. Exactly.
Sure.
Yeah.
Where it's like, how is anyone else going to sell hot tubs without using the words hot tubs?
Yeah, exactly.
Right.
And so you're just pretty much not going to get that under one exception. If you use a mark that is descriptive long enough, and so extensively geographically, extensiveness in volume, extensive in time, then you can get what's called acquired distinctiveness. You weren't distinct to begin with, but you acquired that recognition so that when consumers see that mark, they don't immediately think of the descriptive words, they think of the brand.
Sure.
Perfect example, Stitch People.
Stitch People. Yep.
That is exactly how you got your registrations.
Right.
Yeah. And so there's a store out there called the Company Store.
Oh yeah.
That's one that's similar. Best Buy. That's another one that was considered
but they've been around long enough. They're big enough that it's Best Buy.
Exactly.
Yeah. Interesting.
And so that's the fuzzy descriptive area.
Sure.
That one definitely takes more work, as you know, to build the brand.
I think we had, is it 4 years?
5 years.
5 years. Okay. I was going to say, I remember 5 years of like established doing of business and using it and logos and distribution and like just all of the things that you mentioned. Right.
Exactly. So you can get protection. It just takes more work and more time.
Right. Okay.
And then the last category is generic. You can't get a registration for a generic word. So if I'm selling chocolate chip cookies, I'm not going to get a registration for chocolate chip cookies.
Right.
Nobody gets to have a monopoly on the name of the product itself.
Sure. Interesting. Well, that's for the best.
Yeah. And so something I always tell people is, don't pick a descriptive mark, but if you have to pick a descriptive mark, add something to it. It's going to make your life easier. So for example, Apple used to be Apple Computers, and then ultimately they dropped computers. So you can take that time to build up some recognition. If you do apply for a descriptive mark, say it was Apple Computers, the trademark office will just make you disclaim exclusive rights to the word computers.
Okay. Oh, I see.
So you have rights over the mark as a whole, but other people can say computers.
And you can't get mad about. So somebody used the word computer.
I love that.
Exactly. Wow, I didn't know copyright covered so many interesting things. Can you tell us when, if you start a business, at what point do you think about copyright and trademark? At what point do you know if you should seek to register it? Or is it even necessary? Could you tell us a little bit more about that? And also, I have heard that a lot of people think, well, just by the fact that it exists, I have copyright on it.
Yeah.
Can you tell us about that kind of common belief too?
Yes. So copyrights, a copyright does exist as soon as it's created.
Right.
However, there are so many benefits to registering it within a certain time period of its creation. And particularly for people who are in the business of selling something that is primarily the copyright is the value of it, I would highly recommend doing that. What registering it early allows you to do is, if you ever have to sue on it, you can request attorney's fees, which that's going to be your biggest expense.
Right.
And most importantly, if you ever do have to assert it and sue on it, you can ask for what are called statutory damages. So if you ever have to sue somebody for infringement of a copyright, you have to either prove your actual damages, which would be either how much you lost by not being able to sell it. For example, maybe you're in the business of licensing stock images. Somebody used that stock image without your permission or without licensing it, then you were out the X number of dollars that you normally charge. Or you can recover their unjust gains. So what they inappropriately earned as a profit selling your work. The problem is that
somebody makes $10,000 selling soda in what looks like Coke bottles and people think they're buying Coke, Coke can say, hey, you owe us that $10,000 because people thought they were buying our product.
Yes, that's on a trademark perspective, but the damages analysis
that's right. That was a
same.
Trademark.
That is the damages is the same type of analysis, though.
Right. Yeah.
And on top of it, in trademark, you can also say, and you damaged our brand, our reputation, so we want even more. And you knew it was ours, so we want even more.
Right.
But under the copyright, for example, you draw some like amazing illustration, put it in a book. Somebody goes and takes that book, copies it, blows it up and sells it as a poster and makes, $40 off of this poster. That's $40 that you're out.
Right.
That was wholly your product, your effort of your mind. So you can recover that. Now, that takes a lot of work in any kind of a dispute to calculate those damages. So when you register early and you get something called statutory damages, you can demand up to $150,000 per copy of that because you registered it. You did everything you were supposed to, basically. And they have what's called constructive notice of your registered rights. So that it really eases the burden on having to prove damages if you ever have to assert it.
Okay.
Yeah.
So you can just start there and just say with all the labor, all the time, all the registration.
Yep, I did all of this.
All the sales you did, all the confusion, all the damage. Like you could just, the law agrees that starting at $150,000 is the point.
That's
the point to start at.
Pretty much. Yeah.
Okay. Interesting.
So
all right.
that is, I mean, a court can, so it's ultimately the judge who will decide what the statutory damage is. It could be less than that.
Okay.
But you can, the best benefit of that is it just takes the burden off of you to have to prove it.
Okay.
So that's really helpful, and it's really inexpensive to register a copyright. It's depending on whether you register in the name of your company or yourself individually, it could be $35 or $85 is the filing fee.
Okay.
So it's really low. And in certain situations, I would, you can register a group of them, but I would definitely talk to a copyright attorney before trying to do that on your own.
Sure.
Because in some situations, if one member of that group of works falls, the entire thing falls, and it can get very complicated. Yeah.
And now when we were starting Stitch People, I remember we found databases online where we could search, just like you search to see if a domain name is available, you can search to see if a trademark is available or see if other things exist. I guess I'm saying that partly just so that people know that that's an option, but I would imagine that involving a copyright attorney is somebody who would help you do that due diligence to make sure that whatever it is you're seeking a trademark on or seeking a copyright for doesn't already exist and isn't already protected.
Sure. And on the trademark side of it, there are a number of factors that go into determining whether or not a trademark is available. And so we call those before the trademark office, it's called the DuPont factors. And they're the same factors that are used when you analyze whether a trademark is infringing. But basically, a trademark owner has the right to prohibit any third party from using the same or similar mark for the same, similar, related, or complementary goods or services. So that's pretty broad. So when you say same or similar, then, changing an S to a Z is not going to make your mark distinguished from the other one.
Right.
If you have a registration for shoes, then somebody else can't go and sell socks under that same mark. Or even have, for example, a retail store featuring clothing and you have a registration for shoes. Those things are considered very related. And so there's this area around rights that need to be considered also. And trademark attorneys, we do that all day long. So
Sure.
that is something that I recommend. But there is a way that I tell all my clients to do this before paying me to do it, to see if a proposed mark that you want is available. And that is one, look at the trademark office's website, look at their database, and that would be a quick way to knock out certain things if it's obviously not available. The second is that with trademarks, like copyrights, it doesn't have to be registered in order for you to have that trademark, but having a registered trademark gives you much wider rights and many more additional benefits, particularly when and how you can enforce that trademark. So you'll want to look for unregistered rights also. And the best way to do that is just Google it. If I, again, I'm inspired by your wallpaper. If I say, I want monkey clothing, I can go and just Google, monkey clothing, monkey brand clothing, ape brand clothing, ape jungle clothing. And I can see what's coming up and see if there is something that is, in that realm that might prohibit me from using that brand in that same industry.
Right. That's really interesting. I like that. Like you said, you can look for unregistered, but even unregistered trademarks exist, just like an unregistered copyright. So that's still something to be aware of. And whether registered or not, the person who's had it for a while, especially if it is on that farther end of the spectrum of distinct, then has rights to protect that.
Exactly.
And defend it and
exactly.
keep it.
Yeah.
That's great. So tell me a little bit more. So a lot of times, I think a phrase people are familiar with as far as copyright goes is copyright infringement. We getting into the digital age, that happened a lot with, piracy and Napster and, all the music. And especially now, all the talk is about NFTs and how that's going to be easier to protect and not have people, copying your memes and copying your stuff around the internet, which honestly, I could have a whole part 2 about this because I don't understand how memes work that use the likeness of people from shows where you have like the show's protected, the person's protected, the network's protected, but now we're copying this image into a meme. Anyway, all sorts of questions.
We could talk about that a little bit.
I'm going to put a pin on that because that's fascinating to me. But can you kind of define for us What is copyright infringement, and what does
Yes.
that look like? When do you run into that?
Sure. We're going to back up just one step
Sure.
and talk about what rights does a copyright holder have.
Oh, that's a great place to start.
So just like a trademark owner can prevent others from using the same similar mark for same related goods, a copyright owner, first of all, something that's protected by copyright just has to be an original work of authorship. It doesn't matter who does it first. If you and I both get off this call and we sit down and we draw two different pictures of trees that are somewhat similar, we both equally own copyrights in our trees, no matter who finished first. So a copyright, that's kind of a very simplistic description of a copyright. The rights that a copyright owner has there's 6 of them. The first is to make copies of whatever work they have. Distribute copies is the second one. Create derivatives is the third one. Publicly display or publicly perform. And then in the case of music, to publicly disseminate it digitally via digital transmission. So the first few are the ones that are going to implicate like your type of work
Sure.
most. Make copies, distribute copies, derivative works, publicly display. Those, if you exercise any one of those 6 rights without the copyright owner's permission, then you have infringed their copyright.
Sure. Can you define for us? So I'm thinking of like, okay, if I write a novel, then then that copyright belongs to me, and it is up to me to it's in my discretion to, like you said, make copies of it. So now I'm printing multiple copies of my book, and then that second one you said is I am now selling that book. I'm distributing it, selling those copies. Can you tell us what exactly is a derivative work?
It's a derivative work. Yes. And this is one that gets complicated and fuzzy sometimes, particularly in the mind of artists, because there's this notion that all great artists copy.
Sure.
Yeah. And so a derivative work is one work based upon another work. An example of this would be like a 1.0 to 2.0 in software, or a sequel to a book, or a series of paintings that all kind of came from that first one, and you do another series and you have a bunch of them. An adaptation, a book to a movie, anything that's based off of that original work is a derivative work. And distilling this a little bit further and talking also a bit about infringement, something I'm always asked or that tends to confuse some people is the concept of being inspired by something versus copying something.
Right. Which, like you said, that's a huge discussion among artists is, I saw this, I was out and about and I saw this thing and that inspired me to, or that gave me the idea to.
Exactly.
Or are you just stealing an idea, or are you just taking, what's the difference? Where do you draw the lines? Yeah, that's a huge conversation.
So going back to how copyrights protect a particular fixed expression, that particular expression versus the concept of that is embodied in it. For example, Leonardo Da Vinci, Mona Lisa, he'd never owned the copyright in the concept of portraits, but he owned the copyright in the Mona Lisa. And so that's the distinguishing point there. So for example, I go and I'm at Target and I see a greeting card, and on the front of the greeting card is a pig and a hula hoop. And I think that's hilarious. And so I go home and I decide to make some posters of animals doing different fun sports, roller skating, jump roping. I'm not infringing that because it's just the concept that inspired.
Right. Animals doing sports.
Exactly. I'm not taking a pig and putting it in a hula hoop, but just making the pig skinnier, or, changing the color of the pig, or
taking a photo of the greeting card and turning that into a poster and hanging it on your wall.
And people have come to me and said, well, hey, I made this change here and I turned, the ears on the cat this way. And, I moved the stripes around. I changed 10% of it. Isn't that not copying anymore? I'm like, that is a wives' tale. That is an urban legend. There is no percentage that is some magic number that you can change and have it suddenly not be a derivative work or a copy. And when it comes to copying, somewhat related to this, is that it's not a matter of quantity that is, partially it's quantity that is looked at to see what is copied, but it's also quality. So for example, Casablanca, the Here's Looking at You Kid. If somebody goes and takes Here's Looking at You Kid, those are just a handful of words in a whole movie, but that's kind of the heart of the movie.
Right.
And so that would still be infringement. So there's no magic number as to how much you can quote unquote take.
Interesting.
What you can do is be inspired by the idea or the concept. So say I was, coming up with a greeting card, we'll use that example again, and I see a painting and I'm like, oh, I really love that color combination. And I see, another greeting card and it has the use of flowers to signify growth. And I see an album cover and I love the script along with like the really hard background.
Yeah.
They're all elements that would be technical inspiration.
Sure.
You're not copying them. You would be taking ideas and concepts and creating your own thing.
Yeah.
That is not infringement. That is being inspired. But if you were to actually take the flowers from the greeting card and put it on top of the album with the script in the background and
using the same script and the same layout.
Exactly. Yeah. Then you start getting into more, you're just copying.
Sure. So one way that I don't know if I heard it this way or when people ask me about it with my limited knowledge, to me it's, and I'm asking you because I want to run it past you if this is accurate. Yeah. If I'm an illustrator and I draw Mickey Mouse as we know him, but I make his shoes green and that's like my little take on it, that's copyright infringement. That's a derivative work and copyright infringement because it's still Mickey Mouse. And even though I changed the color of his clothes, I'm only drawing him because we all know who Mickey Mouse is and we know and like him. Versus if I see Mickey Mouse and I'm like, that's just funny. Like you said, animals doing sports, animals in clothes. And even if I draw my own mouse that looks nothing like Mickey and I put him in a little outfit, well, now I've created my whole own character.
Exactly.
That is inspired by another mouse in clothes, and I've made my own mouse in clothes. But it looks nothing like Mickey, and no one would confuse the two.
Exactly. And another example, saying we'll stick with Disney for a little bit. Donald Duck, he's a character, he's a cartoon. Yeah. The Aflac duck does not infringe Donald Duck.
Right. Not at all. Totally different.
Exactly. Yeah.
Interesting. Okay.
So
I like that.
Yeah, that's a really good explanation of a derivative work that you have there.
Well, thank you. Versus, another one is how, and maybe this is getting into a different part of the conversation too, but like you mentioned the Mona Lisa. So if I'm an artist and I make like a Mona Lisa painting, but it's like a cat, that is a derivative work because the reason that's funny is because everyone knows the Mona Lisa. Yeah, and that's a famous painting. But I can do that with that painting because that's a 600-year-old painting. Public
domain.
It's in the public domain, and so that's okay. And so that's a legal derivative work of the Mona Lisa.
Exactly. And talking about public domain, there's this sometimes a misconception that publicly available means public domain. And public domain means the copyright expired. That's the only thing that it means. Or no, I'm not going to say it's the only thing it means. It also could mean that there was never a copyright because it just didn't rise to that level of creativity.
Sure.
Which means there was just no copyright. So if it was just, a red circle.
Right.
That's too minimum.
Or a very common phrase that never was claimable by anyone.
Live, laugh, love.
Right.
That drives me crazy. Yeah.
Yes.
So that's what public domain means. Something that I do come across on a somewhat frequent basis is that people will find things online and they'll say, oh, well, I've had very sophisticated clients at marketing departments say, I found this on a YouTube channel and they said it was free. And they've launched this national marketing campaign. And
Ruh-roh.
YouTube is not a lawyer. It's not public. Just because it says either it's free online or it's public domain or you see it on a Wikimedia page, investigate. Sometimes you can find something that is truly public domain because it's expired. Right. So look at rule of thumb, look at the life of the author plus 100 years. That's going to give you the likely expiration date, but there are so many laws that came in between that may affect that going back also. So it's not a guarantee, but if you see that the author died in 1960, then don't even go down that path.
A little too close.
Yeah.
But if the author died in 1860, you're probably in the clear.
Exactly.
It's a safe bet, but still double check.
Yeah. There have been so many, actually Disney has lobbied hard to get certain copyright terms extended and some reversion of copyrights. And so it does get messy. And I know actually a lot of copyright lawyers won't ever like give advice saying for sure whether this is in the public domain or not. They'll say likely or not likely.
Interesting.
So because it is such a fuzzy area. Right. Something you can do is Google the Cornell copyright expiration chart. And that is, I mean, every lawyer that I know kind of has that bookmarked. And it gives you a whole chart of when it was created. Did they do this? Did they do that? When does a copyright expire? It's interesting, but at the same time reminds you of like, oh my gosh, this area of law really needs to be cleaned up.
Yeah, it's complicated. So this kind of, like you mentioned, we've gone into some Disney territory just because it's such a well-known brand and well-known character marks. Can you talk a little bit about licensing with intellectual property, and when does licensing happen? How does that relate to to making something legal versus not infringing? You know, just kind of talking about that whole thing.
Yeah. So licensing, remember those 6 rights we talked about under copyrights. Licensing is giving somebody permission to exercise one of your rights. And so you can give them permission in the copyright context, for example, to exercise any of those 6 rights.
So a writer giving the publisher the right to print and distribute the book.
Exactly.
Make copies.
Exactly. And you can put additional limitations on those rights. For example, I have a client who licenses a lot of designs for products that are sold in certain stores all over the US. And they have limitations on what stores geographically they can sell
like North America or that kind of thing.
Yeah. Okay. Or this store versus that store, even if it's not geographic, maybe there's 2 stores throughout the entire US and they say you can sell in this one and not in this one.
Okay.
You can put a number. This is really common if you ever license stock images, if putting a limit on the number of copies that you can use or make. The type of use, is it going to be a commercial use or is it for personal use?
Right.
For example, I can license a stock image to put on my personal blog. There's no commercial element to it at all.
Right.
But if, Stitch People has a blog and you put a stock image on it, then it's commercial because it's promoting this business. And that extends to social media also. For example, if you run a travel agency and you find a image online and it says, it's free, except for commercial uses, you put it on your travel agency's Pinterest, you're now using it in a commercial sense.
Right.
And so you are stepping outside of the license. So that's moving on to your second part of the question is, when you have a license, this is the right you can exercise, and these are limitations on it. If you step outside that right, you're infringing.
Sure. Right. So if you are an author and you work with a publisher to make copies and distribute those copies, and then they go ahead and make a movie deal to turn your book into a movie, that is a derivative of your work that they are not licensed to do.
Exactly.
Not okay. Right.
Exactly. Okay. Yeah.
So tell me about this is one thing that, we get a lot of requests because, people love their characters. People love Disney princesses or the Seinfeld cast or whatever. We have always erred on the side of not touching, anyone else's intellectual property.
Correct. Yeah.
Jerry Seinfeld's likeness belongs to him, even in cartoonified cross-stitch form. We go to the extreme to just not cross those lines. Can you just, to be just sort of frank for this part of this discussion, explain how, a Stitch People likeness of someone, like if Spencer and I have been watching Seinfeld lately. So if I wanted to do a Stitch People portrait, my artistic interpretation of these 4 very famous and distinct characters, how is that an okay thing to do? At what point does that become not an okay thing to do? Because like you said, the stock image might be free until commercial use or what have you. So if I want to make a Seinfeld portrait, tell me how that would be legal and then also not.
And this also relates to your memes also.
Right. Yes, there you go.
So keeping in mind the business aspect of the Seinfeld brand, the studio and all that. Okay. So it's obviously a very well-known series. I think I've watched every episode 10 times. So
There's a reason we get along.
Yeah, I know. If you were sitting in your house and you're like, I love this, I want this like super cheesy Seinfeld, portrait on my wall, and you created it for yourself and you put it on your wall, nobody is going to care.
Right.
Yeah, you're not misappropriating their likeness because it's not a commercial context. You are technically infringing because you are making a copy of something, like, for example, a still of like, the photo of the cast. You're technically infringing on that front. Studio is not going to care because you are not selling it.
Yeah, they'll never see it. It's in my house.
You're not making copies of the pattern and selling those. So there's the technical side of it, and then there's the business side of it.
Sure.
And if you put you put Seinfeld on it with their logo and all that, that is when it's, I'm not going to say, okay, it's a technical infringement, but you're not likely to receive any action from it.
Right.
But when you start capitalizing
because technically any copy is not okay for any, very technically doing something even for fun for myself and putting it on my wall is not okay. But since I'm not selling it, like you said, it's unlikely they're going to even know or come after me.
Yeah, exactly. And like, again, it goes back to like the proving damages and stuff too. That would be like, what are their damages?
Right.
But so that is, like you said, boiled down to the most technical essence. But when doing things generally for personal use does not attract the eye of these companies that need to enforce and protect their brand. It's valuable to them. And in a lot of cases, they, we had mentioned earlier, for example, costumes and things at Comic-Con.
Yeah.
And how people dress up as characters, or, they might carry around a picture that they drew of a character that they love. And so technically, yeah, those things are copyrights. I mean, they're infringements or either their copies or their derivative works and all that. Nobody cares about that. Generally, that's like, great. You're promoting us. You're showing that you love us. That's a lot of fan art.
Yep.
That is wonderful.
Right. And just like you said, promoting us, there's a point, like, especially at a Comic-Con, where it helps create a little hype that other people are such a fan that they would dress up like Wonder Woman and walk around that at an event like that does help. And there is a cost benefit analysis essentially of letting, even though it's technically against the law, there is a benefit to sort of just letting it happen.
Exactly. There's the business aspect and the legal aspect. And in every business, you think about that from yourself as well. But if that same person sat down and set up a booth and started selling, merchandise, they're going to get a nasty gram from, Marvel or whoever.
Right.
And so that's really the line that there, and I think it's on both sides. It's both in terms of looking at infringement, what is infringing, what's going to catch the eye of Disney or of any of these other large rights holders. If you're doing something for your own personal use, they're probably not going to say anything.
Right.
And it's the same thing from like a small business owner perspective. Like, who are you going to pick and choose to go after from a business perspective?
Right.
Sometimes I see particularly small business owners who their product that they're selling it embodies their hard work, especially as a small business. It's hard.
Right.
And their creativity, and they have a very different emotional attachment to what they're selling than, for example, a giant conglomerate.
Right.
And so that's where, yes, you may legally be right on so many fronts, but sometimes you have to balance that with your business judgment and say, is this worth my time and effort and energy? And that's really hard. And it really often just takes time in the business to start to figure out where to detach a little bit emotionally. And at the same time, also figure out, the business sense of things. Because a lot of times, especially small businesses, people go into it not because they want to start a small business, but because they love what they're doing or they're making. And it's like,
whatever are you talking about? Yeah, absolutely.
Yeah. And so that is something to definitely keep in mind. And, it's the same, like I said, it's both asserting infringement and analyzing, your odds of being sued. If it's non-commercial, so you just want to practice a technique. And so you mimic somebody and you do it over and over again. You're copying the way they do something. It's just for your own personal benefit. And you're not going to go around and sell them. Then you're not likely to have any problem.
Right. So we've, like you mentioned, fan art or a costume at Comic-Con or something like that. Can you tell us what the difference is? Because again, I think there's a lot of, I think the word you used before was like a old wives' tale or lore or something like, well, I changed 10%. Can you kind of speak to these other categories that you sometimes hear of fan art or satire or parody where someone assumes that just because it's their personal interpretation, oh, it's satire. Oh, it's, you know, can you talk about what kind of the differences there are?
Yes. And this is actually perfect to go along with the whole business judgment also. So there is a concept called fair use. And a lot of people have heard of this, but they don't have a complete understanding of it. So there are times when you can use somebody else's intellectual property, particularly copyrights. In some instances, it might also apply to trademarks, particularly logos and such. But there are certain instances where you can use other people's work and it's not infringing. And it falls under a category called fair use. And there's 4 elements that are considered when examining whether something is fair use. The first is the purpose and the character of the use. So is it commercial? Is it non-commercial? What are you using it for? And in some cases, you're using it to critique somebody or to criticize somebody, or you're taking an extract of what somebody said in a speech and you're breaking it apart and saying and commenting on it.
Sure. Like a political cartoon or
something. Exactly. Yeah. And as part of that political cartoon, you might put in text from somebody.
Sure.
The next would be the nature of the copyrighted work. Like, is it super creative or is it, very technical and not so creative? How much of the original work are you copying? Is it the Here's Looking at You kid, or is it the, she turned and said goodbye? It's like those are 2 very different substantive things.
Yeah, right.
And the last element is the effect on the market or the potential market for the work. So those 4 things are considered when looking at fair use. And we have to balance those things we have to balance copyrights against the First Amendment right to free speech, and that falls under fair use also. So satire and parody, those things fall under the fair use type of analysis. And so one of the things that courts often look to is whether or not the piece that is copied, is it in relation to this other message you're trying to convey, this satirical message, this critical message, this parody message? Are they connected, or are you really just trading off of the brand of Mickey Mouse to say this message because Mickey Mouse draws attention and the message is wholly unrelated to Disney and Mickey Mouse? Right. Those are different. And so really the whole concepts of satire and parody and any other kind of fair use, like whether something is educational or not. A lot of times people think, oh, it's educational, it's fair use. And that's not where the analysis ends. You look at it as a whole. And all of these, like everything that I'm talking about today, these are all huge, broad generalizations. And so, and every situation is unique. So again, anybody out there, talk to a lawyer. But fair use is one of those things that is probably the most drilled down, most fact specific type of a defense. And satire and parody will fall under those things. But in an effort to keep closer to the satire and parody exception of infringement, let's call it that, if it's related to what you're copying, you're more likely to be in the safe zone.
Okay.
So if you're criticizing Starbucks and you're taking that Starbucks logo and you're making it into something else, and that something else message is critical of Starbucks, you're likely to be okay.
Sure. So
taking that, and then you move over into the business side of it. Now, Starbucks, Louis Vuitton, they went after Chewy Vuitton for dog toys or treats or something along those lines.
Interesting.
So they're doing their cost benefit analysis, and they're gonna have a problem with it. And they can make a colorable argument that you're infringing, and you may have a colorable argument that it's satire or parody. Their business judgment is going to jump in and say, you're capitalizing on my brand. They're going to do something. And especially if you're going after a smaller company, it's going to be easier for them to go after the smaller company than it is going to be for the smaller company to defend against them.
Yeah, right.
And so that's just something to be aware of.
Sure.
That's not to say you can be right or wrong. You could still be in the right, and from a business perspective, choose to stop doing it.
Right.
So that's again where business judgment and legal judgment are two separate analyses that affect each other still.
Interesting. Okay. I'm just going to check my little bullet point list here. We definitely we've covered so much good stuff. One thing I want to, just before we get to a couple general questions I have for you, sort of, we've touched on these topics of all good artists steal, or I was inspired by this, or we've touched a lot on that. Can you speak to crediting, yes. giving credit to, if you were, let's go back to that, Mona Lisa example. If I'm an artist and I recreate the Mona Lisa, but instead of a wryly smiling woman, I put in a cat because that's funny. Assuming Leonardo da Vinci were alive, it would be hard because the copyright would still be active, blah, 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 blah. But what do I owe to Leonardo da Vinci in that case? Let's go with the fact, if he were alive, it would be in a licensing agreement to what, and I need to credit him. Yep. Let's assume it is what it is, and he's long since passed. Do I have to say anything about him?
No. Credit in the United States is not required ever. So it's not going to, if you have a license, unless it's in a license agreement, obviously, if you have a license to use somebody's work, and that license might say, we require that you give us credit. And sometimes it'll even say the format that you do. Some stock images, for example, require credit and some don't. Right. Depending on how you're going to use it.
And sometimes that's the difference between it being free or not. Where it's like, you can use it for free if you give credit.
If you give me credit. Yeah. But something that I see this on Instagram all the time. Somebody will post a picture and they'll say, credit so-and-so.
Yes.
I'm like, okay.
That's what I'm getting at.
That is not going to get you out of a copyright infringement. So if anything, it's showing that you knew about it and you're copying it.
Yeah, that it's not yours.
Exactly. Yeah. So it's not required, and it's not a get out of jail free card. It's not going to get you anything. There's another thing that I see on Instagram a lot that says, no infringement intended. Contact me, for credit. And I'm like, that's not going to get you out either.
No. And also adding credit after the fact isn't going to help.
Exactly.
It's not going to fix it.
Something that increases damages in an infringement case is whether or not the infringement was willful. And a lot of times people think that, like, I didn't know it was protected under copyright, so I didn't willingly infringe. And it's not the willing to infringe that is the willful part. It's the willful making of a copy. It's like, I put this photograph down on the copy machine and I hit copy. That's willful. Even if I thought the photograph was in the public domain, I willfully copied it. Right. So that's those like disclaimers and attempts to like legalese your way out of infringement isn't going to. Just saying, I'm not doing this intentionally.
Yeah. I was going to say, because that kind of speaks to that meme land that I think is just so confusing.
So the meme thing, it's kind of like the Seinfeld thing. They're going to pick and choose what they go after. There are actually some really funny Seinfeld memes. Oh, yeah. But they, studios really not going to have a problem with that unless it's disparaging their character. Right. And then they might, they might send some takedowns to Instagram or to Twitter or wherever it may appear. But you have, again, business judgment, you pick and choose your battles. Yeah. And for very broad, very huge brands like that, they're not going to care about that. Right.
And if anything, people sending back and forth Seinfeld memes just puts you in the mood to watch an epised, and that benefits them in the long run.
Exactly.
So, interesting. So, so here towards the end of our discussion, one thing I would love you to tell us is, what do you wish everybody knew about IP law? What do you wish was just like the common knowledge about copyrights or trademarks?
I think the thing that I wish everybody knew that I think would make both my life and their life so much easier is that Google and Reddit and YouTube are not lawyers. I think it's very important to do your research and educate yourself.
Right.
But be very aware of confirmation bias. Don't gravitate toward the answers that you don't gravitate toward and believe the answers that you want to hear. Look at it all around and explore on your own. I think it's definitely important to be educated.
Right.
But at the same time, there is also a reason why, lawyers like me exist.
Yeah.
That's not to say that you have to hire, the top most expensive lawyer and go to them for every single thing. But I think it's definitely important to establish a relationship with a lawyer and treat it as a part of your business, the way you would somebody who handles your finances. Or if you have, employees.
I second that.
HR.
I can attest.
Yeah,
I can absolutely tell how helpful it has been to have, like you said, we don't go to you for every little thing, but when there's something that comes up and it's like, should we try and register Stitch People as a trademark? What would that take? What would that benefit be? How do we do that? That has been invaluable. Just so helpful to know that we have somebody in our corner who knows the answers.
Sure. Yeah. And it's like, and especially if you can find somebody that, especially for small businesses, I've worked at big firms and little firms. I've had tiny startups as clients and Fortune 500 companies as clients. If you can find somebody to work with that is comfortable working with small businesses and is going to understand your business concerns as well as your legal concerns, that's really important. And who isn't, you're not just going to go through a trademark filing or copyright filing mill with somebody,
right?
Somebody that you can actually talk to and strategize with and can help you balance, priorities. And is it going to tell you that you need every single thing available? Well, maybe you need only this subset for at least the first few years of your business. Then when you get up and running and start doing this, and maybe you expand, but it definitely needs to be considered as part of a business expense.
Absolutely.
And it's, if you think of it from that perspective from the beginning, it actually will save you money in the sense that, because budget is everything for small businesses. It will save you money because it's less expensive to prevent problems than it is to fix them.
Oh, what a quotable quote that is. That's so true. And it forces you to get clear on the big question of what's the point, especially for small businesses and crafters and artists where it's something you love, it's your passion, it's your hobby, it's your creative outlet that sort of melds into a business, and now you're selling it, and now you're running a small shop and a e-commerce. And oftentimes people don't stop and take the time to decide what the point is. And I will just share, I remember having a conversation with you very early on with Stitch People. We said, people are going to use our patterns to make portraits and sell them. It's how I started. It's going to be a very natural offshoot. What are the legalities there? Should we be worried about that? And you really helped us with that legal versus business conversation of, well, technically that is a physical thing that they've made, and it's like their interpretation, and it's a little hazy, but that you helped us hone in on what's the point of Stitch People. It's our patterns, and it's enabling people, it's educating people, it's teaching you how to do it. It's the process, it's the mix and match patterns. It isn't ultimately the final portrait product that we're concerned about, having a chokehold on. That's not, the whole point is actually empowering people to make those. Yeah. So it really helped us get clear on the point, which is, it seems so simple, but it's so easily missed, especially by small passion, based businesses.
Yeah. Yeah. And you can, and if you're looking for a lawyer, obviously, you can look in the usual sources and look in your local bar associations and all of that. But Google and see what people do. Like, I have seen some really cool lawyers, especially in this area of law. That's the best part, is that anybody who's doing copyrights and trademarks and just those are like, they're usually like interesting people who have an interest in creative things. And I've seen some,
like a museum background.
And I've seen lawyers with very fun and interesting blogs, and you can poke around and find, especially you can find small shops and see who you're going to connect with and whose personality is interesting to you. Or if you're in a particular industry, I have a lot of apparel startup industry, like clients. And, if you work with an attorney who has that, interest as well, you see a blog of theirs or something that, the organizations they belong to, then they'll have a little bit of that like business insight that might help you also. And so like find somebody that you connect with.
Yeah. They're a member of your team.
Yeah, exactly. Yeah.
Right. And just like you said, you sometimes have to meet a couple people, go through if you find a good fit,
like dating.
Just like you would with any relationship. I love that.
Exactly.
And what that you kind of spoke to this, but what would make your job a lot easier when clients come to you?
Coming to me before there's a problem. That's the obvious one. Don't pick a descriptive trademark. Even I know you did initially.
I know.
And
but that was the thing. We didn't come to you first. We came to you a little after the fact and went, well, what are we doing here?
So,
but we put in our time.
When you come up with a brand, don't get incredibly wed to one. You'll have a favorite, but have a couple in mind that you want to protect. Know your industry, kind of get an idea of what's going on out there, because it may be an industry, for example, that I am clueless in, and then it would be interesting I have never represented anybody who did any kind of embroidery before you guys came along. So there you go. But that's what I would say. Don't pick a descriptive name. Be ready to educate your attorney on your industry, if they don't already practice in that industry, if it's not like an obvious industry like apparel or something, and come up with some ideas about some goals, like what are you trying to get out of it, and that would definitely help provide some guidance.
I love that.
I definitely do not expect clients to come to me understanding what intellectual property is. Nobody does.
Right.
And
well, like you said,
okay.
And it's so contextual and so case by case.
Yeah. And it's so, that's not their job either. And so it's like, you come to me, tell me what you do, what's important to you. What are you, tell me about your industry, and why do you like this brand? And, tell me those things. And then I can help you whittle out what you have.
Right.
And that's where I think, working with an attorney, not only to help you in your particular business, but also to educate yourself, obviously, as well. Like even just listening to this podcast is a great starting point to start having some bells go off in your head of like, hey, that applies to me. Hey, something along that line would be helpful.
Right.
And, explore those things. And those are all kind of like, threads to pull that could lead to something great.
Absolutely.
Yeah.
I love that. And that kind of answered my final two questions were like, what advice would you have, or what small steps can small businesses, especially artists and creators and crafters take to protect themselves legally, and what advice you might have? And it sounded like you tapped into it a little bit. Just kind of be prepared of the direction you're wanting to go, what your goals are, and take the time to even just have a consult with a lawyer, just one conversation even to say, what do I need to do? What do I need to think about? And maybe your goals don't demand that you register this and protect that and go, you might, but at least an expert like yourself would have the context to be able to give that advice.
Exactly.
And to just invest the time and that, the fee or the money or whatever you might, like you said, it'll help you save money in the long run.
Yeah. We may see those golden nuggets in there that need protecting that you don't see just yet.
Yeah.
That in the long run will actually protect you from spending money later. And then I would say also, there are so many free resources out there that are better than, like I said, Google. Not to say Google's terrible. You're going to find a lot of great stuff on Google too. But there are so many startup organizations, especially like I'm in Southern California. We have so many startup events, like at least 5 a week, just generally in Orange County, of different startup support organizations where they will have a speaker come. And look, you get all this free advice, and everything ranging from taxes to, intellectual property to renting your first, retail space, all this stuff. So tap into those organizations. It's hard for artists to tap into the business side of things so many times. I mean, the creative mind does not work the same as the logical business mind. There is a little bit of communication in varying degrees with different people, but that's a big one, is to check into those resources. And especially during the pandemic, so many of those resources have been put online. So if you can
even
find
easier
startup organizations, that's great. A great way to get some free advice. I would say also, kind of do a bit of a self audit and like, what do you have? What are your, like you were talking about this, what do I have? What is it that I make? What is this? This kind of sounds like what Lindy was saying about copyright. This kind of looks like what Lindy was saying about patents, whatever it is, kind of do a self audit and keep an idea in your own head of what what do you have from an intellectual property perspective? What do you think that you have?
Right.
And record keeping, that's another really big one that is not,
Amen.
does not come naturally for artists either.
Nope.
And so, for example,
Can confirm.
yeah, if you are,
Yep. But we are paying for it, years and years later. It's like, oh, where did we find the thing? And when did we do the other thing? And
yeah. And especially if you are using something as inspiration, that is a really good way to keep track of where things came from. So 5 years from now, if you go and you put something out and you're like, was I using this as a practice copy, or is this original to me, or what did I do? And so keep track of like how you came up with things, like the inspiration file, like don't copy these things. These are just inspiration references.
Right.
And, these are my original things, kind of record keeping, when you sold what to who.
Right.
If you do make copies of something and start selling them, when did that first take place? Just kind of like general record keeping all around. And you'll be so surprised at how much that those things become useful sometimes years down the road.
Yeah, that's really, really good advice. Well, Lindy, thank you so much for your time today. I find this stuff very fascinating as well, as you can tell. I'm like, I could talk forever about it with you. But I think there's just some things that I wish I had known when I started, that thank goodness we found you a couple years in and we were able to make sense of what we were doing. Like you said, it's a hard thing for a creative brain to wrap its head around logistical things sometimes. And it's nice to just sort of have it all laid out and summarized and like you said, just listening to this podcast and saying, letting yourself think about, that reminds me of what I'm doing, or maybe I need to look into that, or I didn't know that was a thing, or, that's how that worked. I didn't realize. All of that is really just invaluable for makers.
And, with everything that we did talk about today, it was all, broad generalizations and just a lot of concepts that come up pretty frequently, but especially in this area of law, because it is so subjective, it's not an objective black or white situation. That, everybody's situation is going to be unique. So you should definitely, if you heard something that you said, you think, that sounds like me, particularly in the infringement context or fair use or something like that, I definitely encourage you to talk to an attorney about your specific situation.
Right.
Because these were very broad generalizations that we discussed today. So definitely don't take that as legal advice for yourself personally.
Right. Legal seeds, legal whisperings, not official legal advice.
Yeah, exactly. Exactly.
Right. Yeah. Wonderful. Well, thank you so much, Lindy. It is always a joy. What a great conversation. I cannot tell you how much I enjoyed talking with Lindy. I think this kind of stuff is fascinating. Of course, I'm easily interested in all sorts of things, but I feel like this is such a diverse and robust world. Like Lindy mentioned, everything is contextual and everything is sort of case by case. But even just the general overview of what she does, the kinds of problems she solves, and all the different branches of intellectual property law in the United States, I think it's just so fascinating, so interesting, and just so, again, diverse and robust, and just so much to learn and dig into. I hope you learned a lot. I hope you enjoyed this episode. And as always, thank you so much for joining us. It is a pleasure to have all of you listening to the Stitch People podcast. It has been so fun to get your feedback and to hear what you think. Thank you for being here and for enjoying conversations with Stitch People like you and Stitch People helpers like Lindy. We'd appreciate if you could take a moment and subscribe to the podcast. Leave us a rating and review if you haven't already. Honestly, that really helps us out. It helps us get, more cross-stitchy goodness into the world with all the algorithms and everything that control our lives. You can check out everything Stitch People has to offer, cross-stitch patterns, cross-stitch books, merch, and more at stitchpeople.com. And connect with us, please, on Instagram, Pinterest, and Facebook. We're Stitch People anywhere you look for us. We'd love to see all your crafty works in progress. So tag us or send us all of your photos and projects. Lastly, I want to thank all of you in the Stitch People community for your support of us and your positive and cooperative encouragement of one another. I'd also like to thank the incredible Stitch People team for making all the magic happen behind the scenes. Our fully licensed jazzy tunes were created by Jonathan Boyle, and our sound designer extraordinaire is the one and only Brandon Yost. Have a wonderful day, my friends, and happy stitching. The Stitch People podcast is a production of Beanski LLC and Stitch People. Copyright 2022, all rights reserved.